Hello everyone, welcome to the presentation by Centre Law Consulting on bid protests and the most prevalent grounds for sustaining bid protests. My name is Wojciech Kornacki. I'm a government contract and compliance counsel at Centre Law Consulting. My practice includes government contract litigation, procurement integrity, contractor responsibility and debarment matters, business compliance, and bid protests. This presentation on bid protests is provided for educational use only to general public. For specific questions, it is always best to consult with an experienced counsel. Now let's look at our agenda for today. This is our agenda for today. First, we'll talk about key statistics from the Government Accountability Office, or GAO. Next, we'll look at the most prevalent grounds for sustaining protests. This is where agencies are making most mistakes. Finally, we'll look at the form selection, deadlines, and remedies. Now let's look at our statistics for this presentation. Let's start with cases filed. As you can see, since 2011, the percentage of cases filed with the GAO has increased by 13%. This is a significant increase, and most observers attribute this to more competition between contractors and greater scrutiny of government solicitations. The sustain rate is another important statistic. It actually has gone down by 1%, but this may be driven by two factors. The first one is that there are more and more cases that have been filed. And the second one is that agencies are more willing to take corrective action. Corrective action means that a federal agency agrees to fix the alleged procurement improprieties before the GAO decides the case. When the GAO agrees to take corrective action, the GAO will dismiss the case, and it will never decide the case on merits. So the sustain rate only shows the cases where the GAO has actually decided the case on the merits. And this brings us to another key statistic, the effectiveness rate. The effectiveness rate has increased to 45%, even though there are more and more cases filed. This is significant because it means that the federal agencies are more willing to look at protests and take corrective action before the GAO decides whether it should rule in favor of the protester. The additional benefit for federal agencies is that they don't have to pay any costs for filing a protest. So this could be one of the reasons why they're willing to take corrective action. Another one could be that they simply recognize that there are more mistakes. Now, there are two other important points to make about this slide. Is that currently the GAO is working to upgrade its bid protest filing system, and also introduce a filing fee for filing a protest, and this could have very significant impact on statistics for 2016 and thereafter. So it's very important to monitor this, and Centre Law Consulting will certainly be doing this. Now let's look at protest phases and grounds. There are essentially two phases where you can file a protest so long as you meet the deadlines. The first phase is pre-award. Here you want to look at the solicitation and you want to examine whether it is unduly restrictive, unfair, biased, or ambiguous. The second phase is post-award. Here you want to focus on the debriefing, questions, answers, and any other information that you may have. Generally, you may want to examine whether there's any conflict of interest, unequal treatment, unstated criteria, or misleading discussions. It's very important to document your protest as best as you can, and also meet any deadlines. Finally, there's two different clocks that are ticking at the same time. The first one is the deadline to file the protest, and the second one is the deadline to request an automatic stay so the agency cannot proceed with the procurement, and this is under the Competition in Contracting Act. Now let's look at the most prevalent grounds for sustaining protests. Each year the GAO publishes an annual report listing the most prevalent grounds of sustaining protests. This is essentially where the GAO finds that agencies make a lot of mistakes. This slide shows that many federal agencies continue to make the same errors over the years. In 2015, 2014, and 2013, the agency sustained multiple protests where federal agencies failed to follow evaluation criteria. So essentially in 2015, 14, and 13, the GAO noted that multiple federal agencies continue to make the same mistake of really not following the evaluation criteria. Also, in 2015 and 2013, the GAO sustained protests where agencies failed to document their decisions. This is important because if you don't receive the award and the agency didn't do proper evaluation or document it, you will only know this once the agency provides the record of their decision-making process. Now, in 2015 and in 2013, the GAO also sustained protests where agencies unreasonably evaluated cost or price. In 2013, this was the last ground for sustaining the protest, but when you look at 2015, this became the first ground. And finally, in 2014 and 2013, the GAO sustained protests where agencies unequally treated different offers. So only because you're not awarded or only because someone else is awarded doesn't mean that the solicitation was followed 100%. There could be other reasons for it as well, and that's important to think about when you think about procurement integrity. Now, once you decide that yes, in fact, there has been a violation, you may file a protest at an agency level, the GAO, or at the U.S. Court of Federal Claims. The agency level is the most informal, and it's usually resolved within 35 days. And the statistics that I have seen show that there's a much smaller sustain rate than at the GAO, and most of protesters file a protest at the GAO level. The GAO level has a limit of no more than 100 days to resolve each protest unless the agency takes corrective action and the protest is not dismissed. If you meet another deadline, there will be an automatic staying effect. So that means that the agency cannot proceed with the procurement, and this is a very powerful weapon. Finally, the U.S. Court of Federal Claims is the third forum. There's really no deadline there to resolve a protest. You may have to ask for an injunction to prevent the agency proceeding with the contract, and again, you will have no time limit, but you will have a federal judge look at the protest and the case. Now, deadlines. I cannot overemphasize this point. Meeting deadlines is critical. You can have the best protest ground, but if you miss a deadline, the GAO will most likely not consider it and the protest will get dismissed. 4 CFR 21 discusses all the deadlines for filing a protest. Also, please keep in mind that right now there's a proposed rule that could have some impact on the deadlines or on some evidence or other aspects of meeting the deadlines. So please keep this in mind. It's very important to meet all the deadlines. The GAO will generally dismiss any untimely protest. Finally, the remedies. It's very important to notify the GAO what remedy you're seeking when you file the protest, because this will allow the agency to also consider whether they should just grant the remedy, and also this will help the GAO decide whether the protest has merit and the relief should be granted. The GAO has a broad range of remedies. When filing a protest, it is also important to specify whether you seek costs for preparation or litigation of the protest. Also, it's very important to document this, because if it's not documented, the GAO will sustain an agency denial of your request or your claim for reimbursement. Thank you so much for joining us today for this presentation. We appreciate the opportunity to speak with you, and if you have any other questions, please let us know.